Hi guys, it's Kathy. I hope you're doing well. So, here's what happened. Hold on, I gotta put myself back together. Oh, sugar. I do not want to cancel this morning live stream. I just don't. So, I thought that I would, so I just got off work not too long ago. I just got off work, and I thought I would get a premiere ready. That way, I won't be here at 4:30, but you guys can be here at 4:30. And I would have a premiere ready. So I just sat here and recorded 2 hours for you, and then of this premiere for this morning, and then I was getting ready to start OJ, so that we can also do OJ, even though I won't be here. Because really, I just got off work. It was long. And I had accidentally hit start streaming instead of start recording 2 hours ago. So I just did a whole live stream, which went nowhere because I didn't set up a live stream on YouTube or anything. You know, this stupid software just let me go on and on for 2 hours, streaming into nothing, saving it nowhere. So now I have to start all over again. It is 2:23 a.m. and the live stream starts in 2 hours. So I can do it. I'm gonna tape my eyeballs open and get this done. So by the time you guys start streaming watching the live stream as a premiere, I'll be recording OJ. That way, OJ will be ready in 4 hours. Yep, don't worry, we're gonna get this done. It all fell apart, but you know what? We can just do it again. You know, that's just 2 more hours. I'm gonna stay awake. I can do it. Look, Arizona green tea, which has caffeine in it, will keep me awake. We're going to get this done. We are not freaking going 3 days in a row without a live stream. It's just not going to happen. Caffeine will pull us through again. I'm a mess. It's okay. My hair was in a ponytail all day, so it's all, you know, right, Bobby? When you wear your hair in a ponytail, Bobby, for 13, 14 hours, you know what I mean? I'm still in my work uniform, and there's cat hair on me, because while I was streaming with you guys just a little bit ago, there was this orange cat all over me. Oh, it's so shitty that I lost that, because while we were streaming together, which we weren't, the orange cat got on me and was sitting on my lap like this, right? But she was pointed that way, away from me. She couldn't. She wanted to turn around, but she didn't. I know that she wanted to turn around, and she kept turning her head and like starting to bring her paw like she was going to turn around, and then she would just get confused, and then she would turn her head back and look that way. She would remember that's not what she wants to look at. So then she would turn the other way and she would lift up her paw, but I don't know. I don't even know how orange cats made it this long. I just don't understand it, because I finally put her out of her misery and picked her up and turned her around. But you guys missed it because I pressed start streaming instead of start recording. Anyway, I'm just going to do it different than I did it last. I'm going to go to Bleckley County first. Oh, hold on. That's not Bleckley County. Sorry, I know that's rude. Now I have to go back to where we were because we just watched this. Now we have to watch it all over again. It's okay. Don't worry. What is that? Alright, I'm going to start it just like a minute before Kelly comes up. No, I'm wrong. I'm just wrong. I need to go back further. This is the the oldest case on can't breathe all of a sudden. Blakely County's docket. I'm getting there. I had it ready in our first stream together. So yeah, the reason why I'm doing this, the reason why I'm doing this premiere is because I just opened and closed 2 days in a row. Not doubles, opened and closed. So I'm tired. I just got off work a couple hours ago. I just got home like 2 hours ago. And then I did the first live stream real quick, and that didn't work. So there's no way I can stay awake and make it through this morning. So I'm doing the best that I can. Instead of canceling for the third day in a row, we're going to do this premiere thingy do where I'm talking to no one for 2 straight hours, and then you guys can chat with each other in chat, right? And if I am still recording OJ when this starts, which I will be, I can chat with you maybe. Right? I just gotta find Maxwell. I'm just looking. I'm so close. I think this is it. Okay. I'm just gonna start right here. I'm just gonna press play.
Number 2023 R0182, and that was a sentence that you received on April the 1st, 2024, when you pled guilty to possession of methamphetamine, and you were given 3 years probation. Do you remember that case and that sentence?
Yes, sir.
This petition reflects that it was served on you on November the 20th of 2025. Were you in fact served on that date?
Yes, sir.
And would you agree with me that more than 3 days has passed since you were served with the petition?
Yes, sir.
Can you read and write?
Yes, sir.
Are you a United States citizen?
Yes, sir.
Have you been over this petition with your attorney, Mr. Deal?
Yes, sir.
And Mr. Deal is representing you here today. He's standing with you at the podium. Have you had enough time to talk with him about this petition?
Yes, sir.
Are you satisfied with the services that he has rendered to you in regards to this petition?
Yes, sir.
This petition alleges that you have violated your probation as to one count, that on or about the 23rd day of October 2025, you failed to complete the probation detention center time you were given. Do you understand that allegation?
Yes, sir.
And do you wish to admit or deny the allegation?
Yes, sir.
Well, one or the other.
Admit the allegation, sir.
All right. And do you understand that you do not have to make an admission here today?
Yes, sir.
You could deny and we'd have a hearing,
Yes, sir.
and the state would have to prove that you violated your probation by a preponderance of the evidence. Do you understand that?
Yes, sir.
And at that hearing, do you understand you'd be entitled to have Mr. Deal represent you?
Yes, sir.
And do you understand you'd had the right to confront, question, and cross-examine all of the witnesses and people who accuse you?
This is too far back. So, but every time I try to get to the right spot, it brings it back. So I have to pause it, and I'm gonna go there. There we go. It wouldn't let me fix it. So
Go ahead and bring that bench warrant up, so let somebody else from the public defender's office handle it. Let's bring him.
Maxwell work.
Huh?
It's a dead document.
she was on the dead docket. Not her dead, like dead docket, like her case was dead. I literally can't deal with a technical issue right now.
All right, the court calls, State of Georgia versus Kelly Denise Maxwell, 2021 R0189. Ms. Maxwell's before the court on a bench warrant. Her case also was, it was placed on the dead docket in November of 23, reactivated February of 24, then placed back on the dead docket in September of 24, reactivated January of 25, and placed back on the dead docket August of 25.
That is correct, Your Honor.
All of this, you'll hear her charges. All of this for these charges.
What are we doing with Ms. Maxwell?
Your Honor, Miss Maxwell was actually en route to court the last time, and she got picked up in Bibb County, where she spent approximately.
See, now this is the part where it's hard, because Eileen would be telling us right now where Bibb County is. I've never heard of Bibb County. I don't know any judges from Bibb County. I don't know any courts from Bibb County. Never heard of Bibb County. Is it up north? Is it south? Is it east? Is it west? Eileen would be telling us this all right now. But no, we're in a premiere. Maybe she's telling you guys though. Or she's talking about her cats. One of those two things are happening if she's there.
Approximately 2 to 3 months in jail. We figured out during the course of the time when we couldn't find her that she was actually in jail in Bibb County on a burglary. So that's where she was, and that's why she missed court. We have the correct address. The first time, the address was listed as 313 Jay's Place. We fixed that, and this last time it was the fact that she was in jail somewhere else, and we didn't know she was in jail somewhere else.
I got a job interview Friday. I got me a new car. I promise you, on my life, on my kids, I'll be at the next court hearing.
Ma'am, I would suggest that you let your lawyer talk.
Don't say nothing.
What's the state's posture?
It ain't up to me, something.
Your Honor, the state's posture would be that since this case is now active, she remained in custody. I mean, this is a situation that's back and forth. There's no guarantee.
I don't think we can retain her in a punitive sense, Mr. Parkinson, under the law.
Could we do a reasonable bench warrant at the court's discretion then? I mean, bond.
Is she out on bond?
She is, Your Honor.
Bond's already been set. Do I have a motion to modify that bond outstanding?
The bond was forfeited as a result of all these nothing.
I don't know that I don't think the state has moved to forfeit the bond.
I got you. Well, we'll give her another chance, Your Honor.
All right. This is by far the oldest case I have in Blakely
Be
County.
quiet.
Yeah, I stopped it right there because no, sir. You don't just get to say, we'll give her another chance, Your Honor. No, you won't. Legally, you were just slapped down twice, sir. Legally. So, no, you're not giving her another chance. She's where she's supposed to be because of the law. I don't know what it is about this prosecutor. He does nothing wrong. He annoys me. And maybe because I'm just sleepy. I don't know. But he gets on my nerves a little bit this whole time. Even when he's just sitting there, he's on my nerves.
Be quiet.
Be quiet.
And I want it handled one way or the other.
Yes, Your Honor.
I'll put it on my next plea calendar. I'm sorry,
What?
we'll do it December the 11th.
12, 11.
Send Candy a note that I need to do an order.
Your Honor, to cover my, we'll defer to the court, whatever the court tells us to do, but I would like to hand her a notice if I could before she leaves, so I can say I gave it to her.
And I would like to get a correct address, because I have 113.
That's right. The 313 is not right. The 113
I don't
is.
know that Miss Dokey's in there, I mean, it's lunchtime.
Okay.
We couldn't handle it today, right now. We need a probation. We need a probation.
Your Honor, we can handle this case today.
Okay.
Can I have just a moment to do plea sheets with her?
Where are we at with Mr. Brown?
Your Honor, we're going to go ahead and handle the revocation today. We've already executed the not guilty plea as position 40. And I anticipate we have a resolution as to the revocation.
All right, let's get Mr. Brown.
It's just so hard to be in this courtroom without Mr. Kelly, without the judge yelling at Mr. Kelly. I hope Mr. Kelly has a case coming up again soon. Right?
All right, the arraignment's been handled.
Yes, sir. You waive formal arraignment and enter the not guilty plea.
All right, then in regards to the arraignment calendar, position number 40, 2025 R0183, State versus Marquise Brown. Let the record reflect the public defender's office represents Mr. Brown. He waives formal arraignment, enters a not guilty plea, and he'll have 10 days to file appropriate motions. All right. Then Mr. Brown is also before the court on two petitions and revocations. Each of them are captioned the State of Georgia versus Marquise Brown, one being 2025 R0265 and the other being 2025 R0266. All right, Mr. Brown, if you'll be kind enough to raise your right hand for me, please. Do you solemnly swear or affirm that the testimony you're about to give in both of these cases is the whole truth and nothing but the truth, so help you God?
Yes, sir.
All right. And you are Marquise Brown?
Yes, sir.
Mr. Brown, I'm holding two petitions. One is that the state has filed, in this case number 2025 R0265, and it seeks to revoke your probation that you received in this court on February the 13th, 2025, when you pled guilty to interference with government property and you received a sentence of 5 years probation, and that was in regards to case number 2022R0165. Do you recall that case and that sentence?
Yeah, yes, sir.
And then in regards to 2025R0266 that was filed by the state of Georgia, it seeks to revoke your probation in case number 2024R0112, where you pled guilty on February the 13th of 2025 and received 5 years probation for interference with government property. Do you remember that case and that sentence?
Yeah, yes, sir.
Each of these petitions reflect that you were served with them on November the 4th, 2025. Were you in fact served on that date with these petitions?
Yeah, yes, sir.
And has more than 3 days passed since you were served with those petitions?
Yeah, yes, sir.
Can you read and write?
Yes, sir.
Are you a United States citizen?
Yes, sir.
Have you been over these petitions with your attorney, Mr. Deal?
Yes, sir.
Mr. Deal's here representing you this morning, or excuse me, this afternoon. Have you talked with him as much as you need to about these petitions?
Yeah, pretty much.
And are you satisfied with the services that he has rendered to you in regards to these two petitions?
Yes, sir.
Each of these petitions allege that in count one, that on the 16th day of April 2025 in Baxter, Georgia, you failed to complete the Appleton County Integrated Treatment Facility by refusing to participate in the program. And count two in each alleges that you have failed to pay your financial obligations. In 0265, it alleges that you failed to pay $3,295.08, and then in 0266, it alleges that you failed to pay $500. Do you understand those allegations?
Yes, sir.
And do you wish to admit or deny those allegations?
Admit.
All right. Do you understand you do not have to make an admission here today?
Yes, sir.
You could deny and we'd have a hearing?
Nah, I admit to him.
I'm asking you, do you understand you could deny and have a hearing?
Yeah, yes, sir.
And do you understand that at that hearing, the state would have to prove in each of these cases that you violated your probation by a preponderance of the evidence?
Yes, sir.
And do you understand that each of these hearings you would be entitled to have Mr. Deal there to represent you?
Yes, sir.
And in each of these cases, you understand you'd have the right to confront, question, and cross-examine all of the witnesses and people who accuse you?
Yeah.
And do you understand you'd have the right to defend yourself and bring your evidence into court?
Yes, sir.
And do you understand that you'd have the right to subpoena your witnesses to make them come to court and testify on your behalf?
Yes, sir.
And do you understand you'd have the right to testify at this hearing, but you couldn't be made to testify or made to incriminate yourself in any way?
Yes, sir.
And do you understand you'd have the right to be present throughout the hearing and the right to remain silent
Is
at
he
that hearing
laughing
if
or
you so
crying?
desire?
The inmate.
Yes, sir.
And do you understand that by making the admissions in these two cases, you're giving up these rights for each of these cases and a hearing in each of those cases?
Yes, sir.
Is your admissions here today freely and voluntarily given?
Yeah.
Anyone trying to threaten you or frighten you to force you to admit?
No, sir.
Anyone promising you anything to get you to admit?
No, sir.
Are you sober today?
Yes, sir.
Are you under the influence of any intoxicants like alcohol or narcotics today?
No, sir.
Are you taking any medications today?
I tell my mental health medicine.
All right. Does that
Sir, I've taken a lot of ibuprofen today. A lot. Now, public service announcement. Just because you take more ibuprofen doesn't mean it works better. Quite the opposite. It damages your whole body. Don't take a lot of ibuprofen. That being said, yes, sir, I have taken a lot of ibuprofen today.
That prevents you from knowing where you are and what you're doing?
Oh, no, sir.
All right. Your mind's perfectly clear. You know where you are and what you're doing.
Yes, sir.
Do you have any questions about what I've gone over with you?
No.
What's the state's recommendation in these two cases as they relate to Mr. Brown?
Your Honor, the state's recommendation on both cases is going to be for him to serve 2 years with the Department of Corrections, terminate the balance of probation following that, and it's also giving him credit for time served since September 3rd, 2025.
That's crazy. He's going to jail for 2 years because he didn't take a class? Dumbass. He just didn't take a class.
I'm okay with it. Your Honor, last minute correction, I apologize. So again, it's going to be 2 years to serve with the Department of Corrections and terminate the balance and give him credit for time served since August, Mr. Deal, help me out there.
18th.
August 18th, 2025.
All right. Mr. Deal, you have anything to say about that?
That's what we agreed to, Your Honor. We ask that you accept it.
All right, the court accepts this, and that'll be the sentence of the court. Mr. Brown, in light of the fact that you are being sent or confined to the Department of Corrections for 2 years, I want, out of abundance of caution, advise you that you'd have 4 years from the date that this sentence is modified in which to file a petition for habeas corpus if you feel your constitutional rights have been violated in any way. All right. Anything else from the state?
Nothing further from the state, Your Honor.
Those sentences are to run concurrently.
Yes, Your Honor.
They run concurrently. Mr. Deal, anything else?
Just very briefly, Your Honor, not as to the revocations, but as to position 40 on the calendar. We're, of course, unable to reach a resolution in that matter today, but we did agree in principle, and I would like to just state on the record that when that case does come up, we're in agreement that he will not be looking at further confinement on that. We're going to try to negotiate a term of probation.
All right, Mr. Long, if you'll prepare this.
Great idea, because he just did so well on probation.
Then that, let me sign that. And that leaves us with, the benchmark case.
This case has been open since 2020.
Mr. McLaughlin's
He
ready.
just asked me, was you ready?
I'm ready.
Yeah.
You're waiting on me, you backing up.
That's right, Mr. Speedy Judge. Mr. Speedy Gonzalez Judge. Are jumping beans still a thing? Look, in the 80s there was always these little jumping beans. Are they still a thing? I've never eaten one. I don't know if you're supposed to eat them. I think they're jumping because there's a worm in them. So I would not eat them.
All right. Court calls case number 2021R0189, the state versus Kelly Denise Maxwell. Is this Miss Maxwell?
It is, Your Honor.
Miss Maxwell, if you'll be kind enough to raise your right hand for me, please. Do you solemnly swear or affirm the testimony you're about to give in this matter is the whole truth and nothing but the truth, so help you God?
Yes, sir.
Let me put your hand.
All right. Ms. Maxwell's charged with numerous matters, but she's just pleading to count one,
Yes, Your Honor, she's pleading to,
and the balance will be null pros.
as,
I guess count three is the only other charge against her.
it's correct, Your Honor. As to her, but I think she's named alone in count 3 as well.
Right. She's named in count one with Mr. Riley, and then in count three, she is named solely by herself. In count three, will be null pros.
Yes, Your Honor.
Ma'am, if you'll give us your name and age, please.
Kelly Denise Maxwell, 38.
Are you a United States citizen?
Are you, remember when I said it could affect your immigration status? You're not from like Mexico or Japan, you're from
Are
United
you a
States.
United States citizen,
From
ma'am?
Georgia.
How much education have you had?
I graduated with a special ed diploma.
Can you read and write?
No, sir.
All right. But are you comfortable with that Mr. McLaughlin has represented you and you understand the charges that you are facing?
Yes, sir. He's a great lawyer.
Are you suffering from any physical or mental disease?
No, sir.
Are you now under the influence of any medications, drugs, alcohol, or narcotics?
No, sir.
You are pleading guilty to one count of possession of methamphetamine. Do you understand that charge?
Yes, sir.
And do you understand that this court could sentence you from 1 to 3 years with the Department of Corrections and require you to pay a fine up to $100,000?
Yes, sir.
And do you understand that you had the right to stand on your not guilty plea in this matter?
Yes, sir.
And do you understand that if you stand on your not guilty plea in this matter, you'd be entitled to a jury trial?
Yes, sir.
And do you understand that at that jury trial, you'd be presumed innocent of this charge, and that presumption of innocence would remain with you throughout the jury trial unless the jury were to find you guilty beyond a reasonable doubt?
Yes, sir.
And do you understand that the state would have the burden of proving your guilt beyond a reasonable doubt?
Yes, sir.
And do you understand that at a trial you'd have certain constitutional rights?
Yes, sir.
And do you understand that you'd had the right to confront and cross-examine each witness that the state called to testify?
Yes, sir.
And do you understand you'd had the right to subpoena your own witnesses to testify in your defense?
Yes, sir.
And do you understand you'd had the right to testify yourself and present evidence in your defense?
Yes, sir.
And do you understand that you'd had the right to be free from self-incrimination, meaning that you couldn't be forced to testify?
Yes, sir.
And do you understand you'd had the right to assistance of counsel during trial, meaning that Mr. McLaughlin would be there to assist you in the trial of the matter?
Yes, sir.
And do you understand you'd had the right to be present during the whole trial?
Yes, sir.
And do you understand you'd had the right to remain silent at that trial if you so desire?
Yes, sir.
And do you understand that by pleading guilty here this afternoon that you're waiving your right to a jury trial and these constitutional rights that I've just reviewed with you?
Yes, sir.
And do you have any questions at this point regarding these constitutional rights for either the court or Mr. McLaughlin?
If you have them, you can ask.
No, sir. I just want to go home. That's it.
Mr. McLaughlin,
I just want to go home.
been representing you in this matter. Have you had enough time to talk with him about your case?
Yes, sir.
And are you satisfied with the services that he has rendered to you?
No, I'm not. It just seems like he's very annoyed with her. He's talking, it just seems like he's annoyed with her. I don't know why.
In regards to this case?
Yes, sir.
Have you ever been convicted of a felony prior to today?
Yes, sir.
Then how do you plead to the charge of possession of methamphetamine in case number 2021R0189, guilty or not guilty?
possession of meth, that's it.
Guilty,
Are you in fact guilty?
guilty.
And did you on the
I'll read the date of it.
18th day of December 2020 here in Blakely County, Georgia, unlawfully possess methamphetamine, a Schedule II non-narcotic controlled substance with an aggregate weight of less than 2 grams in violation of the Georgia Controlled Substance Act?
That's, yeah, tell him that, not me.
Guilty,
Ma'am?
guilty.
Yep. It took them 5 years to prosecute her for just having 2 grams of meth. Took them 5 years.
My question was, did you on that date possess methamphetamine?
What does he mean?
He's saying, he's asking you, it's a yes or no question. Did you have methamphetamine on that date that he read?
Yes, yes, sir.
Is your plea of guilty here today freely and voluntarily given?
Yes, sir.
Has anyone tried to force you or coerce you into entering a plea of guilty here today?
No, sir.
If the state would be kind enough to give the court a factual basis for the plea.
Your Honor, on December 18th, 2020, here in Blakely County, Georgia, Blakely County Sheriff's Office deputies Walt Hunter attempted to stop a vehicle that was exceeding the speed limit. The vehicle failed to stop for the deputy. A chase ensued. Ultimately, the vehicle crashed out. Ms. Maxwell and her co-defendant fled on foot from the vehicle. They were caught shortly after fleeing from the scene of the crash, and upon being searched, Ms. Maxwell was found to have an amount of methamphetamine on her person.
And Ms. Maxwell, it's my understanding of the recommendation that you'd be given 3 years probation. You'd be subject to drug and alcohol conditions. You'd consent to a waiver of your Fourth Amendment's right. You'd be banished from the Oconee Judicial Circuit during the pendency of your probation. That means that you could not enter Blakely, Pulaski, Dodge, Telfair, Wheeler, or Montgomery County during the period of your probation. Do you understand that?
Yes, sir.
And if you did, that would be a violation of your probation. Do you understand that?
Yes, sir, and I'm good with that.
And is that the agreement reached between you and your attorney, Mr. McLaughlin, on the one hand, and the district attorney's office on the other? Have there been any other promises made to you in return for your plea of guilty?
No, sir.
Ms. Maxwell, I'm holding a document. It is called an acknowledgement and waiver of rights and intent to enter a guilty plea. It has the caption of the case, or your case on it. I'm showing you that document. You recognize that document?
Yes, sir.
All right, it's got Pulaski County on it.
I'm sorry, Your Honor.
That's why I was so late this morning, I was going to the wrong county.
Sanctions.
Changed that to Blakely County from Pulaski County.
Last letter initial.
Well, you had put your, if you understand what I did there, I wrote Pulaski there instead of Blakely, and I changed it back to Blakely if you'll put your KM under it, just like you did on those.
Up under it?
Yeah, so there's somewhere near it. Okay.
Thank you. It has the caption of your case on it, and you recognize this document, don't you?
Huh?
You recognize this document?
Yes.
All right, this document contains 22 questions or items on it. Out beside those 22 items or questions are the initials KM. Are those your initials?
Yes.
And did you place your initials KM out beside those 22 items?
Yes.
And in doing that, does that reflect that you understood and truthfully answered each of those questions?
Yes, sir.
And does it further reflect that you have not been misled or induced to enter this plea by fraud or mistake, threat, or coercion?
Yes, sir.
And does it also reflect that you freely and voluntarily answered these 22 questions so as to give this court a basis for accepting your plea of guilty in this matter?
Yes, sir.
You signed the document.
Yes, sir.
Mr. McLaughlin signed the document.
Yes, sir.
And you understand that this document's going to be made part of the record in your case.
Yes, sir.
Part of the terms of your probation is that you'll consent to the waiver of your Fourth Amendment rights, which means while on probation, you and your property are subject to being searched without your consent and/or search warrant, and anything found on you and/or your property could be used against you in a court of law. Do you understand that?
Yes, sir.
And do you so consent to the waiver of your Fourth Amendment rights?
Yes, sir.
Had you stood trial in this matter and were convicted, you would be entitled to an appeal, and if you couldn't afford an attorney to represent you in that appeal, this court would appoint you one. Do you understand that?
Yes, sir.
And do you understand that by entering a plea of guilty here today, you're waiving your rights to such an appeal?
Yes, sir.
Ms. Maxwell, I intend to accept your plea of guilty and the recommendation, but I'll give you the right to withdraw your plea and you can proceed to a jury trial. How do you wish to proceed?
Yeah, if that's what you want to do.
Guilty.
You want to proceed with your guilty plea?
You have to answer out loud.
Yes, sir.
The court accepts Ms. Maxwell's guilty plea, finds that there's a factual basis for the plea, finds that she has freely, voluntarily, and knowingly entered into such plea. The court sentences her to 3 years with the Department of Corrections. However, she can serve the same on probation. While on probation, she'll be subject to normal drug and alcohol conditions. She's consented to a waiver of her Fourth Amendment right. While on probation, she also shall be banished from the Oconee Judicial Circuit, and that includes Blakely, Pulaski, Dodge, Telfair, Wheeler, and Montgomery County. Ms. Maxwell, you'd have 30 days from the date that this guilty plea is officially entered in which to file an appeal to this guilty plea if you wish. You'd also have the right to file a motion to withdraw your guilty plea if you file such motion within this specific term of the Superior Court of Blakely County. Do you have a weapons carrying license?
Any weapons? No.
Do you have a weapons carrying license?
No.
I need to inform you, in light of the fact that I've sentenced you here today to a felony, you'd have 4 years from the date that this sentence becomes official in which to file a petition for habeas corpus if you feel your constitutional rights have been violated in any way. Let's let the plea be entered.
Yes, sir.
If you would. All right, this is your name, Kelly Denise Maxwell. The defendant pleads guilty to count one only. This is the 25th day of November, 2025. I'm your attorney, so I'll sign right there. That's the defendant. That means you. I got to get you to sign your name as best you can right above that, okay?
So I'll do anything.
There's no fine in this case?
$500 fine.
Okay,
I'm sorry. I
no
wrote it.
problem. You understand there's a fine of $500, Ms. Maxwell?
Yes, sir.
Okay.
I can pay that. Is that my paper?
No, just hold on. I got you. We're not quite through. Just got to advise you some other stuff.
Okay, Your Honor, Ms. Maxwell's guilty plea's been entered.
All right, is there anything further from the state in regards to Ms. Maxwell?
Nothing further from the state.
Mr. McLaughlin, and anything further on behalf of Mr. Maxwell? Ms. Maxwell?
I just want to put on the record that despite the fact that Ms. Maxwell could not read, I read each and every item in the waiver of rights and explained to her her potential options, and she wanted to go forward, and I believe she is of sound mind and body and knows where she is and what she's doing and made an intelligent, knowing plea.
All right, very good. That'll conclude this matter. Good luck to you, ma'am.
Thank you, sir.
Now
But
you-
I will tell you this, Ms. Maxwell. You do not want to come back
I won't. Thank you, sir.
because you have the potential of going to prison if you come back.
I won't be going back.
All right.
Thank you, sir.
Good luck to you.
Okay. While I was at work today, I recorded Maricopa County. Two little snippets we're gonna watch. This was yesterday. So it was my son's birthday was Saturday, which is still today for me, but yesterday for everybody else in the world. He had to work today too. So we both worked all day. He's 22. Whew.
Good morning, everyone. Please be seated. Make yourselves comfortable. This is the 6th day of the month. On the first day of December, orders were read onto the record that affect all of you regarding DNA and fingerprinting. In just a moment, I'm going to call you up to the podium one at a time. When you get to the podium, I need your name. I'll tell you the charges you're here on. I'll appoint most of you an attorney. I'll set your next hearing date and also give you the location of the hearings. All of you will have release conditions. Your release conditions will be as follows. Do not make contact with the arresting.
Obviously, I have no idea if Bill is here. None. Because it hasn't happened yet. I'm in the past. You guys are in the future. But what if he came and he didn't get his sign? That would just be rude. So I'm pretending, like when I'm recording this, I could just picture what you guys are saying about each person. And I pictured that Bill came in and I said hi to him.
Officer,
Hi, Bill.
do not possess any drugs without a valid prescription. Do not drive a motor vehicle without a valid license. If you're on probation, you'll be ordered to contact your probation officer. If the crimes you're being alleged heard today reflect that there may be a victim, I will order you to stay away from that victim and do not return to the scene of the alleged crime. At the end of your hearing, one of these 3 fine officers will hand it all to you in writing. When you have an opportunity, read it over again, please. Thank you. I now will read victims' rights onto the record. If you are a victim of a crime with a case pending before this court, you have the following rights under Arizona law. You have the right to be treated with fairness, respect, and dignity, to a speedy trial, to be present at court proceedings, and choose whether or not to be interviewed by the defendant or the defendant's attorney, to be heard before the court makes a decision on release, negotiation of pleas, scheduling, and sentencing, and to receive restitution from a person who is convicted of causing you a loss. If you have not already been provided with a written statement of all victims' rights, please contact the Victim Services Division of the Prosecutor's Office. The record will reflect there are no victims present. Mr. Owens, you're first. Come on up, Mr. Owens. And Miss Davis, there's a chair right next to that door. Why don't you hop in the chair and be on deck, so to speak. Mr. Owens, tell me your full name, please.
Brandon Shane Owens.
Mr. Owens, this is 2 counts of armed robbery with a deadly weapon or a dangerous instrument, a Class 2 felony, also 1 count of aggravated assault as a Class 3 felony. I've appointed you an attorney, sir. Your next hearing is December the 11th, downtown Phoenix. Bond is set at $25,000. The next matter, sir, is a probation violation. Same attorney, sir, different hearing date, the 12th, downtown Phoenix. Bond is set at $50. Please reach out to your probation officer. They may have some ideas that might be helpful to you. Good luck, sir. Miss Davis, come on up, Miss Davis. And Andrew Chant is after Miss Davis.
Betty? Is her name Betty?
Tell me your full name, Stephanie.
Stephanie Lorraine Davis.
Miss Davis, this is 1 count of aggravated driving under the influence, 3rd in time, Class 4 felony. 1, 2, 3, 4, 5 different misdemeanor DUI counts, all with different sentencings. I have appointed you an attorney, miss. Your next hearing is on the 11th of December, downtown Phoenix. Bond is set at $5,000. With all driving under the influence charges, there can be driving privileges, revocations, suspensions. Before you hop behind the wheel, make sure you have a valid license or this just gets blown out of proportion. Good luck, miss.
Thank you.
Andrew, come on up, Andrew. After Andrew is Travis. Travis, hop in the on-deck chair, so to speak. Tell me your full name, sir.
Andrew Chance.
Mr. Chance, you have two different matters. The first one is in front of Peoria. They're both in front of Peoria, Judge. It's a disorderly conduct warrant for your arrest. I cannot appoint you an attorney on misdemeanors. Both of these are misdemeanors. The judge wants an unusual bond of $889. You're going to see the judge on the 9th. That appears to be a fail to pay fines and fees, but I do not have the Peoria records in front of me. I'm going to affirm that request of the judge. The next one's, again, out of Peoria, exceeding this posted speed limit by 20 miles per hour. Your next hearing, again, is on the 9th day of December in Peoria. Peoria judge wants a $700 bond. Good luck in Peoria, sir.
Yeah, thank you.
Travis, come on up, and Sierra is after Travis. Good morning, sir. Tell me your full name.
Good morning, sir. My full name is Travis Aaron Conmacher.
Thank you, Mr. Conlocker. This is a burglary in the 3rd degree, a class 4 felony. I've appointed you an attorney. It's also a simple assault as a misdemeanor. Your next hearing date's on the 22nd of December, downtown Phoenix. You're being released to pretrial services. You'll be out of here in about 6 hours. That officer's going to hand you a whole bunch of paperwork. Read it carefully. Those are the terms and conditions you have to follow between now and the next hearing. Good luck, sir.
Sir, do you have any time to answer any questions?
Well, you should ask questions of your attorney. That's why I appointed you one. Okay?
Okay. Yes, sir. I just have never found myself in this position before.
Well, let's hope this is the first and the last time, sir.
Thank you, sir.
Good luck, sir.
Yeah, okay. Who believes him?
Miss Miller, come
Not
on up,
me.
Miss Miller. After Miss Miller is Rodriguez Duce. Good morning, miss. Tell me your full name.
Sierra Nicole Miller.
Miss Miller, this is an assault aggravated, a class 3 felony. I've appointed you an attorney, miss. Your next hearing is the 22nd day of December, downtown Phoenix. You're being released to pretrial services. You'll be out of here in about 6 hours. One of those officers is going to hand you a whole bunch of paperwork. Read the paperwork carefully. Those are the rules you have to follow to stay out of trouble between now and the next hearing. Good luck, miss.
Thank you.
Miss Rodriguez? And then Connor is after this lovely lady. Tell me your full name, please, miss.
Dulce Rodriguez.
Miss Rodriguez, excuse me, this is a dangerous drug charge, class 4 felony. I've appointed you an attorney. Your next hearing date is the 22nd day of December, downtown Phoenix. You're being released on your own recognizance. You'll be out of here in about 6 hours. Good luck. Connor, come on up, Connor. After Connor is Matthew.
How are you?
Good, I hope you are too under the circumstances, sir. Tell me your full name.
Connor Thomas Camden, sir.
Sir, this is a criminal damage case, a misdemeanor, disorderly conduct as a misdemeanor. I've appointed you, I can strike that. I cannot appoint you an attorney on misdemeanors. You're going to meet the Santan judge who can, if they think it's appropriate. Probably not, in my opinion, but again, it's up to them. You're going to see the Santan judge on the 16th of November, and I believe that's off of 222 East Javelina in Mesa. You're being released on your own recognizance. Do not return to the scene of the alleged crime. Do not make contact with the alleged victim. All that's up to the next judge. Good luck, sir.
Thank you.
Matthew, come on up. And Luis Quintero is after Matthew. Good morning, Matthew. Tell me your full name.
Matthew Kirsch.
Mr. Kirsch, this is disorderly conduct as a misdemeanor, criminal trespassing as a misdemeanor. I cannot appoint you an attorney on misdemeanors. That's up to the Peoria judge. You're going to meet the Peoria judge on the 23rd of this month. In Peoria, you're being released on your own recognizance, sir. However, you cannot return to the scene of the alleged crime or make contact with the alleged victim until the Peoria judge says so. Good luck, sir. Be out in 6 hours. Luis. Luis, tell me your full name.
Luis Quintero?
Mr. Quintero, you're wearing all orange. Are you in custody for some other reason?
Yeah, I'm on release today.
Pardon me?
I'm on release today.
You're going to get released today?
Yeah.
All right, sir. Sir, this is obstruct.
Did that judge just look at this guy? Dressed in a prison outfit and ask him if he's in custody? Did he think he was arrested in this outfit? Did he think he dressed up in this outfit to come and see him? Of course he's in custody. Look at him. How do you not know he's in custody? You're the judge. Doesn't the judge have to sign a writ to get an inmate who is in custody in front of him in the court on a court docket? Doesn't he have to sign a writ? How does he not know he's in custody? Why would he ask that?
Obstructing a highway, which is a misdemeanor. I cannot appoint you an attorney. You're going to meet the judge who can. They probably won't. On the 18th of this month, that's at the Encanto Justice Court. That's at 620 West Jefferson, I believe. You're being released on your own recognizance by me, too. You'll be out in 6 hours on my case. The other judge, that's up to him or her. Okay? Good luck, sir. Adam Flores is a behavioral issue. I'll do it as a house call. Disorderly conduct as a misdemeanor, 2 counts, 1 count of criminal damage as a misdemeanor. I cannot appoint attorneys on misdemeanor. That's up to the Peoria judge. He's going to meet the Peoria judge on the 9th day of December. Bond per the Peoria judge is $750 cash. Do not return to the scene of the crime alleged. Do not return to the scene of the alleged victims. Do not make contact with the alleged victim. Christian Escueda has 3 different matters. Christian's also a behavioral issue. Probation violation. I've appointed him an attorney. He's going to have a probation revocation on the 12th, downtown Phoenix. Orders to contact his probation officer. Next one's another probation violation, same attorney, the same hearing date, the 12th, same location, downtown Phoenix. Released on his own recognizance. Again, contact probation upon release. And the last one is another probation violation. Same attorney, same hearing date, the 12th, same location, downtown Phoenix. Same release on his own recognizance, same instructions when he gets out of the facility. Contact probation immediately. Did I miss?
Don't you worry. Guys, don't worry. I was working for a long, long time. I recorded the whole day while I was at work. So we're going to find the next little snippet and keep going with Maricopa County. There we are. I don't hear anything either. If you wait just a few more seconds, we're going to have sound. I can't just forward it to where there is sound because it doesn't work like that. I forwarded it to where there's picture. I'll be the sound, guys. People love it when I talk. Alright, but first off, I think it's too late. See how big, tall this deputy is? Because we've seen a couple girls come up to the podium where their heads are just like right above the podium. And the podium is at below this guy's waist. And I don't know if it's just me, but it looks like a different podium. I don't know. Oh, the camera is up too far. The camera is not at the bottom of the podium. There's a stick and a stand underneath that. Come on, Judge. Please talk so I don't have to. You know me, hate talking. Hate talking. Seriously though, if you like worked with me, or if you knew me in real life, I don't talk. When I'm at work, I work. I'm not chatty Cathy at work. I'm not. I mean, I really, really enjoy my coworkers at this new job. I just do. So, I mean, we talk, but it's not me. It's not me banging out conversation after conversation. If I'm out like with friends drinking at a bar, yeah, we all have a great time. But just me normally, every day cruising through life, no. I'm not even buried in my phone. I am doing what I have to do. I'm working on whatever task is in front of me, and there's not a lot of talking. That's why I was fine coding for a decade or two or whatever. I can't remember how long I was at Millersville. I mean, me and my team, we could go a long time. We could go a week or more without saying a word to each other. Not one word. Maybe send something in an email. That doesn't really count as talking, though. Because we would go into work, we would write our code, and then we would go home. The help desk guys and the networking guys, they like to plan these, like, Friday lunches at the local pizza place. Not Zach's Pizza Place, not Metro, no. And I would go to that. That was fun. Then I would talk a little bit. Mostly I just sat there, though.
All right. Please be seated. All right, this is the 2 p.m. initial appearance calendar for December the 6th, 2025. The court's orders for the taking of DNA and fingerprints that were given on the first calendar of this month will apply to all matters on this calendar. If you're the victim of a crime with a case pending before this court, you're advised you have rights under Arizona law that, among others, include the right to be treated with fairness, respect, and dignity, to a speedy trial, to be present at court proceedings, to choose whether or not to be interviewed by the defendant or the defendant's attorney, to be heard before the court makes a decision on a release, negotiation of a plea, scheduling, and sentencing, and to receive restitution from a person who is convicted of causing your loss. If you've not already been provided with a written statement of all victims' rights, please contact the Victim Services Division of the Prosecutor's Office. All right, Antonio Ibarra. Do we have an interpreter? Okay.
Good afternoon, Your Honor. Yes, Jose Garcia, court interpreter with CITS.
Thank you, sir.
I love it. Crystal clear. It's like he spoke right in my ear. I love this interpreter.
Sir, please state your name.
I wish he was the judge.
Antonio Jose Ibarra.
And your date of birth.
12/28/86.
Antonio Jose Ibarra, 12/28 of 86.
Sir, you're here on two cases. The first of which is a case involving taking contraband into a correctional facility, a Class 2 felony, possession of dangerous drugs, a Class 4 felony, and possession of drug paraphernalia, Class 6 felony. The court has found probable cause. The court has found you to be indigent and appointed the public defender. On this case, there's a secured appearance bond in the amount of $100.
I'm imposing a small bond in this case because you're going to be held in custody on another bond on another case. If you post bond on these two cases, you are not to initiate contact with any of the arresting officers. You are not to possess any drugs without a valid prescription. You are not to drive without a valid driver's license. And you're to continue to provide court or proof of your local address. Your next court date on this case will be a status conference on December the 11th at 8:30 in the downtown Superior Court. There's also a possible preliminary hearing on December the 15th at 8:30 in the Superior Court. Number 16 on the calendar is a warrant. Yeah.
Number 13.
Oh, sorry. Let me correct myself. I was looking at the wrong matter. Number 13 on the calendar on your case is a warrant from the West Mesa Justice Court. On that case, there's a secured appearance bond that's been set in the amount of $250. Counsel has been appointed pursuant to Rule 6.1, and that's the public defender. On that case, there's an arraignment set on December the 10th at 8:30 in the West Mesa Justice Court. The release conditions are the same as any other case, except for the bonds are slightly different. Do you have any questions about these two cases, sir?
No.
No.
Thank you. Next, we're going to call Luis Soto Bojorquez.
Ahora se convoca la causa de Luis Soto Bojorquez.
I don't know what this interpreter is using for equipment, but it's awesome.
Sir, please state your name.
Luis Ramón Soto Bojorquez.
Luis Ramón Soto Bojorquez.
And your date of birth.
28 de agosto de 1992.
August 28th of 1992.
Sir, you're here on two cases. The first of which, number 15, is a new charge, a new case, charging you with possession of dangerous drugs, a Class 4 felony, DUI, a Class 1 misdemeanor, obstructing police, a Class 1 misdemeanor, and refusing to provide a true name, a Class 1 misdemeanor. The court found probable cause on the 3 misdemeanor counts. The court has found you to be indigent and appointed the public defender to represent you. Bond on this case has been set as a secured appearance bond of $1,000. If you post the bond, you're not to initiate contact with any of the arresting officers. You're not to possess any weapons. You're not to possess any drugs without a valid prescription. You are not to drive without a valid driver's license. You're to continue to provide court with proof of your local address. And you're to submit to fingerprinting. Your next court date on this case is a status conference on December the 11th at 8:30 in the downtown Superior Court, with a possible preliminary hearing on December the 15th at 8:30. Number 16 on the calendar is an out-of-county warrant from Pima County Superior Court on 2 counts of possessing dangerous drugs for sale, Class 2 felonies. The court has found you to be indigent.
Sir, I'm just thinking about your future self. I understand that you are young. You have a lot of years to go. But if you don't stand up straight, you're going to pay later in life. I need you to stand up straight. It's not hard. You can buy one of those contraptions. They like make you stand up straight all the time. Perfect posture. But what you're doing right now, sir, is actually causing me pain. I feel pain watching you bend over like that. Stand up straight and pick your feet up when you walk. That's all you got to do. It's just polite.
Counsel will be appointed at the next court date in Pima County on that case. The judge in Pima County set a bond of $5,000. That's a secured appearance bond. I'm affirming that amount. Your next court date in this case will be an arraignment hearing in the Pima County Superior Court on December the 10th at 8:30. Other than that, the release conditions are the same. Sir, do you have any questions about these two cases?
No, está bien, señor.
No, it's fine, sir.
All right, thank you, sir. You can step back to where you were. All right, if you want to make an announcement, if anybody else needs an interpreter, I'd appreciate it, sir.
Absolutely, Your Honor. ¿Existe alguien más presente que necesite los servicios de interpretación al idioma español? Si puede, por favor, levantar su mano ahora.
All right, we will show no hands are being raised. Thank you for interpreting for us, sir. I appreciate it.
Absolutely, Your Honor. Always a pleasure. Have a wonderful
I'm
weekend,
making that
everyone.
a short. I don't know why, but I am.
All right, now we're going to proceed in the following manner. We're going to call two people at a time. The first person will come and stand at the podium. The second person will sit in the chair by the door. The next person we're going to see is Cato Cohen. He'll be followed by Bradley Sorensen. Sir, please state your name.
Cato Cohen,
And your date of birth.
October 17, 1988.
All right, so you've been charged with one count of aggravated domestic violence, a Class 5 felony, one count of criminal trespass, a Class 6 felony, and one count of interfering with judicial proceedings, a Class 1 misdemeanor. The court has found probable cause as to those charges. The court has found you to be indigent and appointed the public defender to represent you. On this case, there's been a secured appearance bond set in the amount of $2,500. The bond is posted. You'll also be subject to pretrial services with electronic monitoring to be installed before your release. I'm going to go over some of your release conditions. They'll all be in writing, but you're not to return to any alleged crime. You're not to initiate contact with any arresting officers. You have no contact with the victim. You're not to possess any drugs without a valid prescription or drive without a valid driver's license. You're to continue to provide court proof of your local address, and you must obey all terms of any order of protections that have been issued against you. Your next court date will be a status conference on December the 11th at 8:30 in the Downtown Superior Court with a possible preliminary hearing on December the 15th. Do you have any questions, sir?
No, expecting you to get a second chance.
I've set the bond at $2,500. You can talk to your attorney at your next court date on the 11th. That's in about 5 days, and maybe that can be changed. But at this point, $2,500 bond with pretrial services. You can step back over there soon. Mr. Sorensen will be followed by Ivan Castaneda. Sir, please state your name.
Bradley Sorensen,
And your date of birth, sir.
6/28/60.
All right, so you're here on a Superior Court bench warrant for failing to appear for your court date on the charge of possessing dangerous drugs, a Class 2 felony. The Office of Public Defense Services has already been appointed to represent you. I'm affirming that. On this case, there's a cash-only bond that's been set in the amount of $5,000. If you post the bond, you're not to initiate contact with any arresting officers, you're not to possess any weapons, you're not to possess any drugs without a valid prescription or drive without a valid driver's license. You're to continue to reside at an address to provide the court, and if you've not already done so, you must submit to fingerprinting. Your next court date will be a post-warrant status conference on December the 16th at 8:30 in the downtown Superior Court. Do you have any questions, sir?
I have COPD, and the reason why I didn't go, I couldn't breathe, so I was in the hospital on my court date.
Okay, and that's something, if that happens, you should contact your attorney. But the bond, go ahead.
I did contact my attorney, but I didn't speak with him. And I don't know if he returned my call or not. And when I was in the hospital, my phone got turned off too, so I'm not sure if he tried to call me or not.
Okay. Well, this bench warrant's been out for some time, and the bond that you previously posted was forfeited. So I set the bond that the Superior Court judge set when they issued the bench warrant. So it's a $5,000 cash bond, so you can step back over there. Ivan Castaneda will be followed by Daniel Penuelas. Good afternoon, sir. Please tell me your name and date of birth.
Ivan Ricardo Castañeda, May 1188.
All right, sir, you're here on 3 separate bench warrants from the Superior Court. First, number 6 on the calendar is charge of 1 count of possessing narcotic drugs, class 4 felony, 3 counts of drug paraphernalia, class 6 felonies. The legal defender has already been appointed to represent you. On this case, there's been a bond set in the amount of $2,500. That's a secured appearance bond. If you post the bond, you're not to initiate contact with any arresting officers. You're not to possess any weapons. You're not to possess any drugs without a valid prescription or drive without a valid driver's license. You're to continue to provide court with proof of your local address, and you're to contact your probation officer within 72 hours. Your next court date on this case will be a post-warrant status conference on December the 11th at 8:30 in the downtown Superior Court. Number 24, it's another Superior Court warrant on the charges of dangerous drugs, class 4 felony, and drug paraphernalia, class 6 felony. Once again, the legal defender is appointed to represent you. In that case, the judge also set the bond of $2,500. The release conditions are otherwise exactly the same, as is your court date of December the 11th at 8:30. Number 8 is another bench warrant on the charges of possessing narcotic drugs, a class 4 felony, and drug paraphernalia, class 6 felony. In that case, the judge also set a secured appearance bond of $2,500. The release conditions are exactly the same. The legal defender is also appointed. Your court date's also December the 11th at 8:30. Do you have any questions about these 3 cases?
No, sir.
All right, thank you, sir. You can step back over there. All right, Daniel Penuelas will be followed by Scott Ostermiller. Sir, please state your name.
Daniel Rafael Pinuelas,
And your date of birth.
9/20 of 95.
All right, sir, you've been charged with aggravated assault, class 3 felony, and burglary in the first degree, class 3 felony. The court's found probable cause as to the aggravated assault. The court has found you to be indigent. The court's appointed the public defender to represent you. On this case, there's a secured appearance bond that's been set in the amount of $25,000. If bond is posted, you're not to return to the scene of this crime. You have no contact with any victim or witness. You're not to initiate contact with any arresting officers. You're not to possess any weapons. You're not to possess any drugs without a valid prescription or drive without a valid driver's license. You're to continue to provide court with proof of your local address, and you must submit to fingerprinting and DNA testing. Your next court date on this case will be a status conference on December the 11th at 8:30 in the downtown Superior Court, with a possible preliminary hearing on December the 15th at 8:30. Do you have any questions, sir?
No.
All right, thank you, sir. Mr. Ostermiller will be followed by Llewellyn Lewis. Sir, please state your name
Scott Ostermiller,
and your date of birth, sir.
12/2/64.
All right, sir, you're here on a Superior Court probation violation warrant. On this case, the court's found you to be indigent, ordered appointing the public defender to represent you. On this case, there's a secured appearance bond that's been set in the amount of $250. If bond is posted, you're not to initiate contact with any arresting officers, you're not to possess any weapons, you're not to possess any drugs without a valid prescription or drive without a valid driver's license. You're to continue to provide court proof your local address, and you're to contact your probation officer within 72 hours. Your next court date will be a probation revocation arraignment hearing on December the 12th at 8:30 in the downtown Superior Court. Do you have any questions, sir?
No.
All right, thank you, sir. You can step back over there. Mr. Lewis will be followed by Angel Thurman. Sir, please state your name.
Llewellyn Albert Lewis III,
All right, thank you, sir. And your date of birth?
June 21st, 1977.
All right, so you're here on a warrant from the East Mesa Justice Court. Go ahead.
I went in on Wednesday, Your Honor, to squash that warrant, and I had $55 on me, and the judge said I needed to pay $100 on it. But I did take the initiative to go in and squash the warrant on Wednesday of this week.
Yeah, the problem is it's the second failure to pay warrant. They definitely don't want you released. They asked for a bond of $570.91. Go ahead.
I just picked up a job and I can pay it now. I can pay it on the Friday. But I do have work now and I can pay it.
Good job, guys. Good job,
What I'm
sir.
going to do,
Good job.
my initial inclination was a somewhat higher bond, but I still have to set a bond.
Your Honor,
Sir, I
got no way to get a hold of
cannot
anybody.
release you OR on a second warrant.
Hell no, sir.
No.
Don't be
If
stupid.
it helps, it helps. If not, it doesn't. I mean, I'm going to set a bond of $250, which is less than half of what the Justice Court was asking for. So bond is a secured appearance bond set in the amount of $250. We'll have to reprint this.
Oh, I wasn't
If bond is
muted. I'm
posted,
sorry.
you're
That
not to
was so
initiate contact
rude.
with any arresting officers. You're not to possess any drugs without a valid prescription or drive without a valid driver's license. You to continue to provide court proof your local address.
I'm kind of wondering what I just said a minute ago, but I don't even care. I cannot redo this whole recording. I just can't. It's almost over now. It's 3:43 a.m. In less than an hour, everybody's going to be expecting a live stream. And I just left my mic on for a little bit, and I have no idea what I said. I know I coughed, and that is rude. And I can't redo it. I can't. I gotta start OJ. Alright, if you guys make it this far, I'm so sorry. I'm sorry. I'm a human being, and, I screwed up. Again. But this is the best I can do to get you guys a live stream today. Can't do any better. I could just mute myself when I'm supposed to. I guess I could do that. But anyway, let's finish this docket correctly. Boop.
Your next court date on this case will be an arraignment hearing on December the 9th at 8:30 in the East Mesa Justice Court. So you'll have court on Tuesday, but that's as low as I can go, sir. All right, you can step back over there. Mr. Thurman will be followed by Erickson Sam. Sir, your name, please.
Hi, sir. My name is Angel Thurman.
And your date of birth.
July 2nd, 1984.
So you're here on two cases. First, number 21 on the calendar is a new charge of possessing dangerous drugs, a class 4 felony, and drug paraphernalia, class 6 felony. The court has found probable causes to those counts. The court's found you to be indigent and appointed the public defender to represent you. On this case, there's been a secured appearance bond set in the amount of $150. If you post the bond, you're not to initiate contact with any arresting officers. You're not to possess any drugs without a valid prescription or drive without a valid driver's license. You're to continue to provide court proof your local address. and you must contact your probation officer within 72 hours.
Okay.
Your next court date is the status conference on December the 11th at 8:30 with a possible preliminary hearing on December the 15th.
Okay.
Your other case is a probation violation warrant. On that case, there's a secured appearance bond that the judge set of $250. Other than that, the release conditions are the same. The public defender is also appointed. On that case, your next court date is a probation revocation arraignment hearing on December the 12th at 8:30. Do you have any questions about these two cases?
Am I getting released today or?
No, you have a bond of $150 on your new case, $250 on your probation case. That's a total of $400.
How long, how many days is that?
Well, your next court date on your probation case is December the 12th. Your next court date on your new case is December the 11th.
Okay.
All right. Thank you, sir. Erickson Sam will be followed by Jose Morrow. Sir, your name, please.
Erickson Sam,
And your date of birth.
4/28/95.
All right, sir, you're here on a warrant from the North Mesa Justice Court on the charge of driving on a suspended license, a Class 1 misdemeanor. The court has found you to be indigent and appointed the public defender pursuant to Rule 6.1. On this case, there's a secured appearance bond set in the amount of $250. If you post the bond, you're not to initiate contact with any arresting officers. You're not to possess any drugs without a valid prescription or drive without a valid driver's license. You're to continue to provide court or proof your local address. Your next court date will be an arraignment hearing on December the 9th at 1 p.m. in the North Mesa Justice Court. Do you have any questions, sir?
Yes, my bond posted today. Is that what's there?
If you posted the bond, they were initially asking for a bond of $500. I lowered it to $250. So have you posted any of the bond?
Okay, well, we already paid the $500.
Okay. Then you should be released later today. It takes a while for that to get through the system.
Right, okay.
All right, thank you, sir.
Thank you, Your Honor.
All right, Mr. Morrow, we followed by Damian Elsmore. Sir, step up to the podium, please, and tell me your name and date of birth.
Jose Mora, April 13, 2004.
All right, sir, you're here on a new charge of aggravated DUI, a Class 4 felony. The court has found probable cause. The court has found you to be indigent. The court's appointed the public defender to represent you. On this case, you're going to be released to pretrial services. You won't have to post a bond in order to get out, but you need to follow their directions. You'll be given an envelope with directions about how to contact them.
All right, thank you.
You're not to initiate contact with any arresting officers. You're not to possess any drugs without a valid prescription or drive without a valid driver's license. You continue to provide court proof your local address, and you must submit to fingerprinting at the arresting police department. Your next court date will be a status conference on December the 22nd at 8:30 in the downtown Superior Court with a possible preliminary hearing on December the 24th. But the court date you need to worry about is December the 22nd. It'll be on the paperwork you'll be given, as we'll make sure you contact pretrial services.
Okay.
You have any questions?
So everything should be on the paper at the court date?
Yes.
All right, thank you.
All right, thank you, sir. All right, Mr. Elsmore will be followed by Daniel Del Sol. Sir, your name, please.
Damian Elsmer.
And your date of birth.
06/21/2000.
All right. Sir, you've been charged with criminal trespass, a Class 6 felony, and custodial interference, a Class 1 misdemeanor. The court has found probable cause, and on those charges, the court at this point does not find you to be indigent, so you're not entitled to a public defender on this case. You're to try to hire an attorney before your next court date. You're going to be released to pretrial services. You'll need to keep in contact with them and follow all of their directions. I'm going to go over some of your release conditions. They'll all be in writing. You're not to return to the scene of the alleged crime. You're not to initiate contact with the alleged victim.
Oh, man.
You're not to initiate contact with the arresting officers. You're not to possess any drugs without a valid prescription or drive without a valid driver's license. You're to continue to provide court proof of your local address. You must submit to fingerprinting at the arresting police agency. Your next court date will be a status conference on December the 22nd at 8:30 in the downtown Superior Court with a possible preliminary hearing on December the 24th. But make sure you contact pretrial services and make sure you're in court on December the 22nd. Do you have any questions?
No, sir. Thank you.
Thank you, sir. You can step back over there. Daniel the Soul will be followed by Jonathan Soto. Sir, please state your name
Daniel Margaret that's all.
and your date of birth.
08-2607.
All right, sir, you're here on charges of possession of a weapon during a drug offense, class 4 felony, possession of narcotic drugs, class 4 felony, and failure to admit that you were carrying a deadly weapon, which is a class 1 misdemeanor. The court has found probable cause. The court has found you to be indigent and appointed the public defender to represent you. On this case, you're going to be released on your own recognizance. You're not to initiate contact with any arresting officers. You're not to possess any drugs without a valid prescription or drive without a valid driver's license. You're to continue to provide court proof your local address. Your next court date will be a status conference on December the 22nd at 8:30 in the downtown Superior Court with a possible preliminary hearing on December the 24th. Do you have any questions, sir?
No, sir.
All right, sir.
Thank you.
Mr. Soto will be followed by Kenneth Begay.
That can't be what he said, so I'm going to let it pass.
Sorry.
I'm just going to let
Doesn't matter.
it slide.
Tell me your name and date of birth, please.
Johnson
name's
A.
not
Soto,
Begay.
October 2nd, 2001.
All right, thank you, sir. All right, sir, you're here on a new charge of possession of dangerous drugs, a class 4 felony, and possession of narcotic drugs, a class 4 felony. The court has found probable cause. The court's appointed the public defender to represent you. Sir, in this case, you're going to be released on your own recognizance. You're not to initiate contact with any arresting officers. You're not to possess any weapons. You're not to possess any drugs without a valid prescription or drive without a valid driver's license. You're to continue to provide court proof your local address, and you're to contact your probation officer within 72 hours. Your next court date will be a status conference on December the 22nd at 8:30 in the downtown Superior Court with a possible preliminary hearing on December the 24th. Do you have any questions, sir?
No, sir. Only question I had was I was trying to figure out how to file for police brutality for the last time when I had to serve my warrant. Because I had 6 officers with their knees in my backs, and I
No, sir,
I just
that's
had
not
I just want to
okay.
know how to go about that.
No
Sir, I
one
can't
puts
give you
their
any
knees in
legal
your
advice. You
back.
can talk to your attorney when you go to court on
To
the
an attorney?
22nd.
Oh, okay.
All right.
Thank you.
Step back over there.
Every day, Your Honor.
I bet there's...
Mr.
sir,
Begay.
No, bring him back.
We're
I'm
followed
not
by
done
Michelle
with him.
Jackson.
Hold on. In today's day and age, I bet there are lawyers all over the place ready for this case. Ready for a 6 knees in your back case. Sir, call around. Call around. You got this.
Sir, your name, please,
Kenneth Gay,
and your date of birth.
5/4/1991.
All right. Sir, you're here on a probation violation warrant. The court's found you to be indigent. It's ordered appointing the public defender to represent you. On this case, you're going to be held without bond pursuant to Rule 7.2 for violating your probation, and the likelihood the judge said when they issued the warrant is that you'll be sentenced to the Department of Corrections. So at this point, you'll be held without bond. Your next court date will be a probation revocation arraignment hearing on December the 12th at 8:30. If somehow your release conditions change and you're released on this case, you're not to possess any weapons, no drugs without a valid prescription, no driving without a valid driver's license. Continue to provide court proof your local address and contact your probation officer within 24 hours. Do you have any questions, sir?
No.
All right, thank you, sir. All right, Ms. Jackson. Please tell me your name and date of birth.
Nashe Jackson, 9/14/2003.
All right, a warrant for your arrest has been issued by the state of California. That state wants you back on the warrant. Were you given a laminated card to review prior to court?
I'm not sure.
Okay.
She didn't receive the application.
Oh, oh yeah, I did. Okay.
Okay. All right, that's what we're talking about. That's what a laminated card means.
Okay.
Okay, that's fine. No big deal. You have a chance to review that at all?
Yeah, I did.
All right. So as I stated, you have a warrant from the state of California. You have a choice to make at this time. You can choose to waive your right to an extradition hearing and be sent back to California within 30 days. Or you could demand an extradition hearing and that a governor's warrant be signed by the governors of both California and Arizona before you're sent back to California. If you choose to waive your right to an extradition hearing, you'd be held non-bondable in Maricopa County Jail for a period of up to 30 days to allow time for California to come to get you. That 30 days would start tomorrow, as long as you don't have any criminal charges pending against you anywhere in Arizona. If you do have criminal charges pending against you in Arizona, that 30 days would begin after those charges are resolved. If you choose to have an extradition hearing, I will set your hearing at a future date. I cannot appoint an attorney on this case because extradition is considered civil in nature, not criminal. You're free to hire an attorney, but you're not entitled to a public attorney on an extradition case. You would be entitled to bond on this case if you ask for the extradition hearing. I believe California was asking for a bond of $20,000, so bond would be somewhere in that amount. If you're unable to post the bond, you'd be held in custody during that time, or until another judge modifies your bail. You don't have to sign the paperwork, but you have to make a choice whether or not you want to waive your right to an extradition hearing or whether or not you want to have an extradition hearing.
So,
Do you know what you want to do yet?
in the extradition hearing, that's basically me getting sent back to my county?
That's sending back to California.
Yeah, and then if I don't, I'm waiting for my county to come get me, right?
Well, either way, you're going to wait for the California to come and get you. If you waive your right to an extradition hearing, they only have 30 days to come and get you.
Okay.
Unless you have charges pending against you in Arizona. If you have no charges pending against you in Arizona, they have 30 days to come and get you.
Mm-hmm.
If they don't come and get you within that 30 days, you'd be released.
Okay.
If you want to have an extradition hearing, they would have 90 days in order to hold that extradition hearing and have you sent back. But if you waive your right to an extradition hearing, they'd only have 30 days, but you'd be held in.
Sorry, Judge. Oh, my camera's not working. Judge, you forgot to ask her. Look, she's in orange. You forgot to ask her if she's in custody by any chance. Maybe she's not.
In custody without bond for that 30-day period.
Without bond?
That means you couldn't post bond. If you asked for an extradition hearing, you would have a $20,000 bond that you could post during that 90 days and still fight extradition to California.
Can I'll keep my bond.
All right. All right, so we'll show the defendant's not waiving her right to an extradition hearing, which is fine. And you can always change your mind during the extradition proceedings, during the next 90 days. If you decide to change your mind, you're free to do that.
Okay.
All right. So we will show. All right, so we would set this for a fugitive from justice initial hearing on December the 15th at 1:30. You'll go to court, the judge will explain more of your rights, and the process will be getting going on having the extradition hearing.
Sounds good. We have to stop now because it's 4 o'clock. I don't know how long it's going to take for this stupid video to upload and process. I'm hoping I can make it by 4:30. So I have to stop recording now. Oh gosh, outro or no outro? The outro was too long. I don't have time. I lost my outro. That's alright. It's alright. At least we got a live stream up. Alright guys, I'm gonna start OJ now. I'll see you there. Well, I won't, because I won't be there. But I hope you guys have a great Saturday. I should be me and live tomorrow. Which I don't know what day tomorrow is. It doesn't matter. Whatever 24 hours from now is, I should be live. All right, guys? Thank you so much for coming out. I appreciate you. I really do. Bye, guys.